cool, so please hold on tight. I know NBI has purposely only allowed 30 minutes for GST because people do fall asleep when these sort of discussions. So I hope in this next 30 minutes I could presentation I have prepared for you. Hopefully it's helpful. I really think the whole concept of GST and the problem that many advisors or attorneys have with it is that it doesn't get used as often. It's the same thing that you don't find a lot of estate planning attorney that handle estate tax planning. This sort of GST really becomes an issue, and you really need to know a lot more about the different nuances and different rules that are applicable as you get to deal with more larger estates. So I really think that's probably one of the reasons. But hopefully in the next 29 minutes, I could give you some information so you feel a little bit more better about GST, taxes, generation, skipping transfer taxes, and then obviously using a dynasty trust and the benefit of that. That's part of this whole presentation as well. So GST is really a transfer tax. It operates in parallel to gift and estate taxes, but it's its own tax. So, you have gift tax, and then sometimes the transfer might be subject to GST tax as well. And I have some examples. The lifetime and death exemption, 13,610,000, tax rate is 40%, and it can be allocated to direct skip or transfers in trust that may result in future taxable distribution or taxable termination. And there's some differences between these things, and we'll discuss that, and we'll talk about who actually gets to pay the GST depending on what kind of transfer do we have. Is it an outright transfer? Is it a transfer within a trust? And some of the other issues there. All right, so let's talk about some of the language and terms that are used within a GST transfer tax arena. You have skip person. That is a person that is defined differently if we're talking about a family versus a non-family member. One good thing about GST is that if you are setting up a pet trust, you don't have to worry about allocating any GST because it has to be a person for GST to be applicable. So, a plan could be that we're going to leave everything to a pet trust to avoid paying GST if we don't know what to do with GST taxes. Probably not the best option, but it could be one of the options. So I want you to think of, I have some sort of board here, and I've written here grandparents, parents, children, and then we have great children. So if you have a transfer from the grandparents to the parents, there might be some gift tax issue. There might be some gift taxes due because that is a gift, but we're not skipping anybody there. So there's no GST tax issues. If the grandparents make a gift to the grandchildren, now we're skipping the parents in the middle. And again, we still have the issue and concern about gift taxes. And let's say if for whatever reason they've already used all their gift tax exemption, then there would be gift taxes due. And then if that person is a skip person, we're also going to have GST taxes due. Let's say it's grandparents to great grandchildren. That we have two skip sort of generation in the middle, but we're lucky you only get to pay it once. You don't pay it twice because it went another generation down. So with skip person within a family, we're looking to see if we're skipping a generation. Grandchildren obviously are usually a skip person. If it's a non-relative, then we look at 37.5 years younger. If you have, in my example here, Joy, she's 90 years old. She's making a transfer in her trust or outright to Tom, her friend / handyman, $1 million. Tom is very happy. However, he may not really get $1 million depending on how much exemption she has left. But that is a transfer that would be subject to GST, and we would have to allocate GST tax exemption. If she all of a sudden decides to marry Tom, and then at that point, it doesn't matter that he's 40 years younger, because it's a family and we're not skipping anyone between spouses, a transfer between spouses, there'll be no GST taxes payable. So here, the question I have, would there be a GST tax if the husband's parents provide a gift to the husband's wife, who is 38 years younger than husband's parents? And the answer is no. Again, if we're talking about a family relationship, we're just looking to see if we're skipping a generation. The fact that the daughter-in-law is more than 37 and a half years younger makes no difference. And so that transfer would be fine, and there'll be no GST tax due for that particular transfer. How about cousins? If you make a transfer to a second cousin, third cousin, that is another transfer that, based on the rules, the transfer, all cousins are treated as being in the same generation as the donor for GST tax purposes. I believe IRS just figured, nobody's going to make a meaningful distribution to their cousin. So if they want to do it, that's fine. But there's no GST tax implication. All right. So we have a skip person. That's the person that is, we're missing a generation. If you're a non-skip person, that is someone that is not a skip person. So that's the easy part with GST. The other easy part with GST is that, imagine grandparents make $1 million distribution to grandkids. That is we were skipping a person. That's a transfer that would be subject to GST. That's the easy part. What gets a little bit more difficult are transfers that are done within a trust, and they refer to them as indirect skip. Direct skip is transferred to a skip person, and it doesn't matter if it's outright or if it's in a trust. If grandparents took kids outright, that's a direct skip. If grandparents in trust for the grandchildren, that's still a direct skip. Indirect skips usually are in the trust, and then there's two different type of indirect skips, which we're going to talk about. The first one is a taxable termination, and then the next one is a taxable distribution. So this part of the GST was a little bit difficult for me to kind of grasp, I remember initially, just because, the way it would be set up is that, as you can see in the example, the father sets up a trust, gives $2 million, transfers $2 million in trust for Daisy. Daisy is his daughter. The trust says all income to Daisy for life, and the time she passes away, whatever it's left will be distributed to Daisy's children, issues. And so, initially you look at this thing, the transfer is in the trust, it's for the kid, for Daisy. But the fact that at some point there'll be a distribution to grandkids, that's the part that makes this trust considered to be a taxable termination. So in my example here, we're saying when Don dies, that would be a taxable termination, because now, I think we have upon D's death. So D is the dad. So we're saying at the time, so it's in trust for Daisy. She gets all the income. As soon as dad dies, that's the triggering event that would go to the grandkids. And that's considered to be a taxable termination, because now the daughter has no more interest in the trust, and now the distributions are being made to the grandchildren. If you are making a direct skip, the grantor, the transferor, they're responsible to pay the GST tax. In a taxable termination, so the trust was set up, a year, 2 years, 10 years, 20 years has gone by, and then the event takes place that now we have a transfer to the next generation. At that point, the trust is liable to pay the GST tax, not the transferor, not the recipient, the actual trust. And the GST tax is based on the value of the trust at the time of the triggering event. In my example here, I have an outright distribution to grandkids. it wouldn't have made a difference if it was that the asset would stay in the trust and now the new beneficiaries were the grandchildren. That still will be considered a taxable termination. The next one is a taxable distribution. And the difference between this is that in the trust, we're going to have non-skip and skip individuals. So in my example, Don sets up, another trust, let's say, gives $2 million. However, he's going to name Daisy and her kids. So they're both discretionary beneficiary of the trust. So now we got a skip person, non-skip person. This taxable distribution, it means we're going to look to see who is receiving the distribution. So let's say the trust is set up. The trustee makes a distribution to Daisy. Daisy is not a skip person. There will be no GST tax due on the distribution. However, let's say the trust makes a distribution to Daisy's child, the granddaughter. At that point, that's a distribution to a skip person. That distribution is considered to be a taxable distribution, and there'll be GST taxes due. The question is, who pays the GST taxes? The GST taxes will be paid by the recipient. The grantor, trustor pays if it's direct skip. If it's a taxable termination, the trust pays the GST. If it's a taxable distribution, the recipient pays the GST out of the money that he or she is receiving. All right, then let me give you an example here. Again, you got grandparents, they're feeling really nice. They'll do $1 million gift to their grandchild, and it doesn't matter if it's a direct gift to them, outright gift to them, or within a trust. If it's set up in the same scenario that the grandchild is the present beneficiary of the trust, that would be considered a direct skip. And the question is, well, how much is this grandchild what would he or she receive? So $1 million, again, we're assuming there's no exemptions left. First, you have to pay gift taxes, 40%, that's $400,000. Then you get to pay GST taxes. The GST tax is not based on the $600,000 left. $1 million gift, $400,000 of gift taxes, $600,000 left. The GST is not based on the $600,000. It's based on the million. So then you have $400,000 in gift taxes. You have $400,000 in GST taxes. The grandson or daughter gets $200,000. Probably not the best way to set it up. Having it in trust and maybe setting up in different ways could be a better option. All right. Let's go next, talk about annual exclusion for gift tax, for GST tax. We obviously are familiar with the annual gift tax exclusion, the $18,000 for 2024. There's also an annual GST tax exclusion for GST tax purposes. Because obviously, if I'm making a gift to somebody, if they're not if they're not a skip person, then I don't have any issue with GST tax. So this becomes a concern if the gift is to a skip person. And at that point, we want to make sure that we could use the exclusion, the annual exclusion for GST taxes. And the reality of it is they're very, very similar. There's only one section that there is a difference in GST annual tax exclusion versus a gift tax exclusion, annual exclusion. And I will tell you what that is very shortly. When we do gifts, usually when you make a gift into a trust, the idea is not for the beneficiary to have present interest. It's like we're making a gift into a trust for our kids or grandkids. And, sometimes in the future, they'll have an interest. However, with gift tax, annual gift tax, and same thing with the GST, if you're making an outright, that's fine, because the reality of it is if you're making an outright gift to a beneficiary, they have immediate possession of the asset. If you're making a gift into a trust, that is not the case. They don't have an immediate possession unless the trust has this crummy rights and crummy powers in there. And the difference that I'm going to talk to you about as far as the GST annual gift tax exemption is how this crummy right is sort of treated. And that's the difference between the two. So this crummy right, it was really sort of manufactured to make sure that gifts that are provided within a trust are done in such a way that the beneficiary could have an immediate possession of it. It was a window of time, right? So crummy rights are manufacture a present interest by giving a beneficiary a limited window of time to withdraw their proportionate share of the contribution. That proportionate time, usually 30 days, 60 days till the end of the year, they're all seem to be, sufficient time. That makes the gift a completed gift. And that's something that we need. The big difference is obviously for gift taxes, there's, with crummy rights, you have certain sort of rules and things that you got to follow. You got to make sure you provide notice. They have to be aware of the amount. They have to know when this power lapses. So those are all the stuff. Again, that would apply for GST as well. However, under 2642C2, you have these two requirements if you're going to try to make the gift also qualify for a GST annual exclusion. One is that the beneficiary before and after lapse has to be the same person. You cannot make the gift into a trust and that gift would be accessible by other beneficiary. And then the other section, the other part of this rule is that that skip person at the time that he or she passes away, the unlapsed portion of the crummy power must be included in their estate. And what that really means is that after the crummy power person, that crummy right sort of lapses, we have to create a subtrust, which the skip person is the sole beneficiary of that subtrust. And also that skip person has a power of appointment over that section. That's the only way you're going to be able to get GST tax annual exclusion for gifts into a trust. If the trust doesn't have these sort of things, then what it means is that we would have to allocate some GST. It's not going to qualify for the annual gift tax, annual GST tax exclusion. All right, then we'll get into this inclusion ratio. That is something that becomes important, particularly when you have a trust that has assets that are in there and not the entire asset is, skipped from or escapes GST taxes. How do you calculate these things? The inclusion ratio is used to determine the portion of the trust or transfer that is subject to generation skipping transfer tax. It's really the non-exempt amount divided into the total value of the trust. They have this thing they call an inclusion ratio of 0, and they have the other end of it is inclusion ratio of 1. Usually we don't want to get a 0, but this is the one place you actually getting a 0 is not a bad thing. If you have a trust that has an inclusion ratio of 0, that means any distributions coming out of that trust, it's not subject to GST taxes. If you have a trust that has an inclusion ratio of 1, that means anything that comes out of that would be subject to GST taxes, particularly if that distribution is being made to a skipped person. And then you have this thing called a mixed inclusion ratio, for example, 0.5, and that really just indicates that distributions coming out of that trust would be subject to GST tax for whatever that ratio would be. Sometimes when you put these trusts together in setting up the trust, and then when you get to administration, hopefully the trust allows for a division of the asset into an exempt trust and a non-exempt trust. Because if we don't have that, it just means now we have everything combined into one. And now any distribution that comes out could have some sort of a, most likely a mixed ratio in there. If you have an exempt trust and a non-exempt trust, realistically, we have transferred, whatever amount of GST left, that amount is transferred into the exempt trust. That trust has a 0 inclusion ratio. Anything that comes out is not subject to GST. And then whatever it's left is transferred into the non-exempt trust. And that trust has a inclusion ratio of 1, which is not the best sort of outcome for GST tax purposes. So in my example here, let's say there is a trust that's funded by $1 million. There's only $500,000 GST tax allocated to this trust. That would mean we have an inclusion ratio of 0.5. And if there is a distribution amount of $100,000 to a skip person, this is now a taxable distribution. We had a taxable termination, taxable distribution. 100,000, half of it, it's got an inclusion ratio of 50.5. That means $500,000 is subject to GST. 40%, 50,000 times 40%, that's $20,000. This was a distribution out of the trust. The recipient would be liable to pay the $20,000. All right, we talked about the exempt and non-exempt trust, inclusion ratio. Now I'm going to tell you some of the sort of nuances with these GST. And there is this thing that could make a difference on how you decide to file the return, timely allocation versus a late allocation. So if you do a timely allocation, you're able to use the date of gift value for purpose of allocation of GST. That means you made a gift last year. Let's say there's Apple stocks. We'll make it easy to value. At the time that you made the gift, the portfolio was worth $5 million. Gift tax returns, 709s, their due date is the same date that the individual files their personal return. So if somebody made a gift last year, 2024, April 15th, that would be the initial date of that you would have to file the return, the last date you would have to file the return, unless there's a extension filed, and then that could push the gift tax return filing to October 15th. But if the gift was done a year ago, worth $5 million, now you get to file the tax return, and let's say the value of the stock is now $6 million. It doesn't matter. You use the date of gift value, 2023, for the purpose of your GST taxes and also for gift taxes. Look at the next bullet point. It says late allocation requires use of value as of date of return. So that means if something happens, the client misses the date, and now it's after October 15th or April 15th, and they miss that, what they would have to do is they could file a late allocation, but they would have to use the value as of the date of return. So in my example, if it was 5 million and now became 6 million, we just sort of gave away $1 million of exemption for no reason, just because the client forgot to do it on time. However, this could play in a positive way as well. Let's say I gifted, at the time I gifted, it was worth 5 million, but when I came to file the tax return, the stock had dropped and it was $4 million. Then in that scenario, I purposely would want to file a late allocation, because then I'm able to use the value at the time of the time of the return. So that saves me $1 million. So we had a client that we ended up, doing the same sort of purposely filing a late allocation just to be able to take advantage of the drop in value. The other thing is this unnatural order of death rule. In my example here, Linda creates a trust for the benefit of her daughter, Amy. Linda gifts $100,000 in this trust in 2023 and 2024. In 2024, Amy unexpectedly passes away in a car accident. She has 2 kids. They become the beneficiary of the trust. Linda, the mom, may now allocate GST exemption to the trust using the date of gifts. So it doesn't matter the 100,000 that she put in 2023 and 2024. Let's say they were invested in Apple stock. They're 150,000. We use the date of gift when we come to file the GST tax return allocation under this unnatural order of death. The next one, which is predeceased parent rule, this operates a little bit different. And in the predeceased parent rule, as you'll get to see in my example, the previous one, the parent had already made the gift, and then something, the daughter passed away. In a predeceased parent rule, the parent has not made the gift yet. Child passes away, and then they'll make a gift to the grandkids, but because the parent has passed away, grandkids move a level up, and so they're not considered a skip person. So in my example here, I have Tom's child, Hannah, dies in 2023. Hannah was survived by 1 child, Julie. In 2024, Tom makes an outright gift to Julie. Under this rule, Julie moved up 1 generation at her mother's death, and the 2024 gift from Tom is not considered a gift to a skip person. All right, then we get to this allocation rule, automatic allocation rule. I believe this automatic allocation rule became law in 2001. And the problem seemed to be that so many advisors and CPAs just forgot to file the return and mark where, the allocation and GST request. So now it automatically allocates GST unless you choose not to, or if it falls within these 6 exceptions. So if you do if it's a direct skip, grandparents gives $1 million to the grandchild, that automatically allocates GST. That's not an issue. It's these GST trusts, and a GST trust, as it relates to this automatic allocation rules, are trusts that are taxable termination or taxable distribution. Taxable termination was completely terminates from 1 generation to the next. Taxable distribution, we have more than 1 generation as beneficiaries, and there's a distribution made to a skip person. And I have the 6 exception here. One of the first one is distribution before age 46 to a non-skip person. I know I'm running out of time. So like this first example I have here, I have Trust A pays outright to children when they reach age 35, so less than 46. Trust A is not a GST trust. We don't have a terminable distribution. We don't have a terminable distribution, termination. I forget these names. All right. So then it's not a GST trust, and so automatic allocation will not apply. And if for some reason we want GST to apply to this, then we would have to manually elect for GST to apply. Trust A pays outright to children when they reach age 35, but only if both grantors are deceased. All children are 18. At this point, this is a GST trust because parents could live to be, older than, they could live much longer, and kids could be older than age 46 at the time parents pass away. All right, so I won't go through the other examples. Dynasty trust, these are a sort of trust. Again, they're irrevocable trust, and intention behind these things is to make sure we have a trust in place that allows asset to grow within it without having it be subject to state taxes and generation skipping transfer tax at every time a generation passes away. The other concept with these things is that as long as possible, we like these trusts to live. So you'll get to see a lot of these dynasty trusts in states like Nevada because they have a 365-year rule of perpetuity. Alaska, 1,000 years. Delaware, there's no time limits. You know, depending, as long as it has assets in there, the trust is going to be there. And obviously, the benefits are that it avoids estates and GST taxes at each generation, provides the long-term financial security for beneficiaries, provides asset protection, and the idea here is that we want to make sure that we have allocated sufficient GST exemptions so that distributions that are coming out are not subject to state taxes or GST taxes. And with that, I am done, Kelly.
Thank you. Now that your head